Hey, everybody. Chuck,
Hey.
this is great to be with you today. It's a good day. We've got some updates to report with our folks. Greg, I don't know if you were on the Facebook page with our 601A folks, but somebody decided to do a poll about what the best settlement would be in the case.
Oh, okay.
Which would be great if we could get the government to talk settlement, which so far we can't because they are. That's the wrong tag. Here we go. Because they are too busy with the judge stuff. So let's kind of give you an update on what happened.
A lot of process news.
Yeah, we had a meeting yesterday with government counsel. On Friday, we met by call with the lawyers of the other two cases that the judge didn't join with ours, but said that he wanted a joint status report from the cases. Obviously, the defendant's the same in all the cases. The government lawyer's the same. But the government, in the other two cases, one is a single case, if I'm not mistaken, Greg, just kind of a one-off 601A. And that lawyer was like, I filed this because I would hopefully get a fast decision. I said, well, now you're part of this case. The other lawyer has about 10 or 11 cases, something like that.
Yeah, like it does.
But all of them meet the criteria of the class in that they all but one of the plaintiffs have a 1-year pending 601A. So obviously they didn't want to join the group, and honestly, we don't care. I mean, it's what we care about is we don't want to delay our case because of their case.
Right.
They're behind us. They filed after we filed. So the government yesterday, when we spoke with the government yesterday, their position was they don't care if they're consolidated, if I'm not mistaken, Greg. They took no position as to consolidation.
Right.
But that if it is consolidated, they would want more time to respond. And here's what they said basically. We have to submit the joint status report on Friday by noon. So we will all do that and submit that joint report by Friday. The government wanted time. The lawyer on our case was not the lawyer on the other cases, so he was not familiar with the other than their status, which was they filed complaints.
Right.
There's been no motion to dismiss, and the government lawyer said that if the court considers, because the court said, look, if we consolidate them, what's the parties' positions on the motion to dismiss? And for us, we don't honestly, Judge, what we view as the problem here, and if the clients know, if the motion to dismiss our case is applied to the other two cases, then each of those lawyers get a couple of weeks to respond to the filed motion to dismiss. The government, I think, would like that because they don't want to have to prepare separate motions to dismiss. But if the judge consolidates the case, he kind of have to do that. So it's a little unclear. And then, of course, the government would have 2 weeks to reply. But we would also get to reply to the government's response at that point. So we get one more bite of the apple. We don't want any of that for our plaintiffs. We don't want to delay this case. We just want a freaking decision on the motion to dismiss. Our discovery is ready to go, Greg, if I'm not mistaken, right? I mean, I've been I was out of the loop for a couple of weeks on trips.
Yeah.
But our discovery is ready to go. We're just this kind of upset the apple cart, so to speak, on the process. Again, these things are.
Well, I mean, part of this is just to remind people we had a change in judge, and it can be disruptive. But we are, we're not, we're ready. So we're just basically trying to keep the process moving as quickly as we can. If the government, wants, if the government needs a little bit more time, hopefully it's because they are interested in settling with us. But we're not holding our breaths on that.
They haven't offered anything, and they haven't responded to our requests for an offer. We've offered them a couple opportunities to talk about how to resolve this issue. Now, let's just look at the plaintiff situation. Greg, do you have the chart up, by the way?
Yeah, I'm looking at it, and we're still kind of frozen without any action. We had some, an expedite request denied in the last week, but otherwise we haven't had anything in June.
Yeah, thanks to the people that requested an expedite, because that actually reinforces our case. They're not expediting anything.
Right.
And we did have plaintiffs provide us with a list of post-filed cases, within the last 12 months that were adjudicated. We're hopefully, again, I was out when that happened. Great, we didn't file that yet. I don't know why, but we need to file that with the judge.
Yeah. Right. And the point on that, just so people are aware of it, is that one of the key arguments that the government always makes in these cases is that if they approve the plaintiffs, you're essentially taking people out of order, and that if they have a first in, first out system.
Well, they've never said that in these particular pleadings. They never actually said those words.
Right. But we're anticipating it.
Yeah.
And that's because that's really their best argument probably for why they wouldn't adjudicate. But that being that's something that we can disprove through data, and we have it. So that's the good news here is that we're able to document that.
Now, I will tell you this: we are still waiting on the end of second quarter statistics. Because all we have are Q1 statistics from the government for purposes of their processing, what they've done. And we know that in the first quarter, they only adjudicated 6,601.
Right. A reminder as well that the government's year is not the calendar year. So the second quarter is January 1st to March 30th.
Right. And now we're almost at the end of the second quarter, which is June 30th. And we don't have a third quarter, and we don't have the second quarter data. Now, we got the first quarter data on April 3rd. So they actually waited through the whole second quarter before they gave us the first quarter data. Which is absolutely outrageous, by the way. I mean, it's absolutely outrageous. They're clearly hiding the information. I mean, they're clearly hiding it, right? There's no other explanation for that other than, oh yeah, we're not going to give this to you because then you know how crappy we're doing our job. So we don't know how many they've adjudicated, but it's clear from our plaintiffs that they haven't adjudicated very freaking many.
Right.
So just to know, you're top of mind, your cases, I know it can be very frustrating. I know how frustrating, because I do this for a living. I've done it for 35 years. Litigation is frustrating, but we're making change. We're forcing change. Hart is one example of that. Although I haven't seen anybody approved out of Hart yet. Have you? No, either. So what are they doing? This is why we need discovery.
Right. Well, one of the things it's interesting because you can't tell what's going on from the website, but we think that these transfers that were all happening were virtual transfers, and that they were not actually physically moving files, but they were changing to this virtual service center, the Hart Service Center. They were changing in the computer system who was ultimately responsible for those cases. So I don't think they were physically mailing files around the country. I think it was all just a computer shuffling.
Yeah, I don't think there's been anything other than that. Other than them, because they don't have Hart on the website yet. I mean, so we don't know how many cases they've assigned to it. We know how many officers they had a couple of months ago, but we don't even know today what the actual situation is as part of this process.
Right. So Chuck, can you lay out sort of like what the next couple of dates are that we're talking about, or deadlines coming up in the 601A case?
So we've got the joint status report due Friday. At that point, then the judge will likely set a hearing, is my guess, on the consolidation, his sua sponte consolidation, or he will issue an order. This judge, just like Tan was supposed to be a fast judge, this judge is quick on the cases we've had with him previously. He's also 88 years old, so I mean, you got to get stuff done quick, right? So he's apparently in good health, and he's a very sharp, very intelligent guy. If I'm not mistaken, if I recall correctly, I think he was appointed by Reagan.
He was. Reagan, who had the broadest legalization program in
the best
immigration history. So even though, don't get scared that he was appointed by a Republican, it was a different Republican.
No, in fact, this judge actually was key in a case Jesse was handling. not more than a year ago, where he gave a very positive immigration ruling, forcing the government to fix a major.
Yeah, I mean, we think we're going to definitely get a fair assessment from him. It's just a question of how quickly we get him.
But hopefully it'll be quick. That's kind of what we are. Right. Our discovery deadline is coming up. We're going to be submitting that. I would imagine next week or so. Our co-counsel is in charge of that, and I think that was kind of finalized while I was gone as well. And then of course we need to get. I will first on the additional filing for the just notifying the court of the fact that the Immigration Service is in fact taking cases out of order. I don't have anything else on 601As, Greg. Let's pop over to 601s. On the 601 litigation, we had government counsel reach out yesterday and ask for 2 additional weeks to file something. Aaron has communicated with that lawyer and said, look, we're not agreeing to that right up front. You need to tell us whether you're filing an answer or a motion to dismiss, because our plaintiffs aren't waiting any longer. So that's kind of, we're waiting to hear back from the government. Our experience is they're going to file a motion to dismiss, and why should we give them 2 more weeks to file a motion to dismiss? There's no reason for us to do that. So, that's if he's going to, but we've also said we'd love to engage in settlement discussions with you to resolve our plaintiff's cases. So let us know which of the 3 options you want to do. So hopefully we'll hear back later today from him after he talks to his client. I don't have any more about that, Greg. Do you?
Nope.
All right. On the EB-5 litigation, let me find my EB-5 litigation. I need to change this because this is actually now called the Iyer case. It's no longer called the Jane case. The government has until I think it's July 15th to provide us the documents in the discovery, and then we will have a couple of weeks to get the follow-up motions done with the court. So they haven't given it yet, and there's a reason they haven't given that information. By the way, I just found out through another means that they have used all of the Indian EB-5s for this year on their quota. Just like, Greg, they've used all EB-3 for India for the quota. They've already used them. They're done. There aren't any more EB-3s for India for this year, period, end of story. I have an excellent source on that I extraordinarily trustworthy. And they don't anticipate any flow down from the rest of the world. Greg, I'm about to blog on this. I'll post a blog later today about the apocalypse of the visa bulletin and what this really means. And I just have to point this out. I pulled up, by the way, a blog that I wrote for AILA in 2009 called The Line? What Line? Where I did an analysis in 2009 of how long it would take an Indian national who filed a labor cert in 2009 in EB-3 and EB-2 to get a green card. And do you know what I predicted?
14 years.
I predicted 15.
15. Close.
15. And most of these folks aren't getting green on 29. The date's not moving from 09 until next fiscal year. So it'll be 15 years. You want to hear the terrible news? Because I just did the same thing with today's numbers.
Yeah, no.
174 years.
Yeah, it's clearly going to require legislative change to get people past the finish line.
And I love the Dignity Act, and it will make a tiny dent, tiny itty bitty, tiny dent, but it would reduce the 175 to about 75 years.
Well,
for new people.
But there's a maximum. I think there's a maximum 10-year wait.
There's a 10-year rule, so that
right. So that really is the solution. I think if you're not going to fix the quota, and then then do something like that.
Yeah. But the Dignity Act, and this kind of goes to what we talk about sometimes our legislative stuff. Is the Dignity Act set for hearing, Greg? Any hearing on the?
No. I mean, the Republican. I don't think that the Republicans in the House Immigration Subcommittee are going to allow any kind of markup on any bill that has a quote unquote amnesty.
No, they're literally not. Right. So they're not, because anything that is one visa more than the current status is an amnesty. That's an amnesty.
Yeah, I mean, really, probably it's going to have to be an aggressive administration that's going to get these numbers down. And I took a well, I didn't take heat on it, but I mentioned sort of the one big one that's out there is changing the rule on derivatives so that it's consistent with the H-1B statute.
Yeah.
Which the two statutes are identical. It's basically referring to derivatives. So they interpret it in two very different ways, the same language. For H-1Bs, H-4s don't count against the H-1B cap. For green cards, spouses and kids count against the green card caps. And there was a lawsuit involving EB-5s on that issue that didn't go great, but it's also different language.
Yeah, it's different. EB-5's got different language on that. So
right. So it's still something I think if the administration, the administration in the past was always saying no, no, no on there, but there have been many issues in the past where they say that the language, that they think that they're afraid of litigation, blah, blah, blah. And then all of a sudden they're not. So this is one of those where I think if the White House wanted to take this position, they'll have no trouble finding a lot of legal scholars who will back them up on that position. And, and they seem like they've been okay with taking aggressive positions on other issues where they know they're going to get sued, like humanitarian parole and DACA. But we'll see.
Yep. So that's kind of where we are on that. I will let you know that my H-1B litigation on the FOIA is still pending. The government's got another week or so on the extension I graciously gave them, and still has not disclosed how many H-1Bs they have issued.
Chuck, just on that, I don't know how much information we'll be able to eventually gather, but at least talking with some of the people in the know, there does seem to be an aggressive move by USCIS to target employers that filed multiple applications for different workers. And it seems like there probably is going to be a drop in the number of people that actually file applications, just because that's a way to basically put yourself in the crosshairs for potential enforcement. And
but the worst part about
some people might go to jail.
So. Greg, the worst part of the enforcement is they're finding a 212A6C fraud claim against the foreign national,
right,
barring them from visa issuance when they had literally, presumptively, nothing to do with some of these claims. There are apparently cases where
I think there's a mix. There are some that are completely innocent. You're right, and then there are some. I think that were just playing the game.
Yep.
And saying, I'm going to use this guy and he's going to get me 10 shots in the lottery.
Especially if they put their face on Twitter, their name on Twitter, and said they did it. That probably.
Yeah. The reason why I'm mentioning this is I think there's we talked in the past about whether we're going to have multiple drawings. And I think that the chances this year are fairly high.
We said that last year too. I
don't think they were not really doing this enforcement last year though.
Yeah, but we were wrong last year.
Right.
Immigration still has not disclosed how many new H's they issued.
That's true. We're assuming that we were wrong.
Yeah, we don't know. There's still about 17 days for this year's lottery cases to be submitted, so we'll see. But I would suspect there's going to be another lottery.
So what they've done in the past, just so people, if anybody's, I don't know if we have any H's in the audience, but what they've done in the past is after the period closes, then they'd wait about 30 days to do their tabulation and make the next announcement. So that would probably be end of July.
Yeah. Last year they did it faster because we were tweeting about suing them. So they did it much faster. So there you go. Yeah. Greg, have you heard any more on the filing fee increase? I've heard nothing.
No, except the fact that they're getting a filing fee increase through premium processing. They've just opened up.
The extortion fee goes up.
I know. I got some grief on Twitter about that. I said it was good news that they were extending premium processing to 539s for changes to Fs, Js, and Ms.
Except it's your kids. These are kids.
I understand that, but how many times have you had people in your office that were basically like their whole future is on the line?
Because they're extorting them. They're literally extorting.
Right, but it was like changing status. It was like if they don't do premium processing for a change to an F and you're in the United States, the amount of money that you're going to spend to go abroad and the hassle of getting consular processing to be able to come back in a timely manner to start your school is way more than premium processing is going to cost you. And the in a lot of cases for some of these people are going to end up having to file mandamus suits because these cases are dragging out so long, and that's also super expensive. So it's just another option. And I would like to see premium processing available in every category, because that's ultimately, if you're going to solve backlog issues, at least then that's one of the ways that you do it. Yep. Is the not backlogs but delay issues in a lot of these cases is offer that, and eventually they will have they'll have more money, and they will have basically a contractual obligation with you to get those cases approved in that time frame, and eventually everybody will benefit once a lot of cases have been moved through.
All right, so there's that from us. With the filing fees, no nibble, no nothing yet. We'll see.
I have not heard any news on that.
We'll see what happens with that. Let's see if by the way, on of course we've got to mention Go and Good Luck and Gomez and Acker. Nothing.
No.
Sorry. Which, Greg, I was thinking yesterday. I'm out of ideas. I don't know what's going on. I don't know what to do.
There is nothing that can be done when you're sitting waiting on a circuit court to issue a decision. You can't sue the court for being slow.
Yeah, unlike the Supreme Court, which kind of has a built-in deadline for June 30th for almost all of our cases. Occasionally they go beyond that, but very rarely. Court of Appeals don't.
Right.
No. So we'll go to questions now and see what we got. Hayes, has the information been filed with the court about? No, it was not, and I was not here, and I'm going to find out. I think the idea was, what is the vehicle that we use to tell the court? Because briefing is done. All right, so briefing is done. So this is more an amendment to our briefing.
Well, I thought we thought maybe in the status report we can include it with that.
Yeah. So we have a status report due Friday, and maybe we'll put that in there. Although I don't think that's the appropriate vehicle. I think it's better simply to say we have an amendment to our reply brief, response brief, and that is this information has come to light, and that's kind of where we are. But the judge he's got other stuff going on, so we're in a good time. Settlement begin. Hayes, we've tried to begin settlement negotiations. Government's not budging.
Yep.
Who is Judge Zilli ruling on after the judge? He's ruling on the motion to consolidate, and then if he consolidates it, he will give the other plaintiffs, a chance to respond to the previously filed motion to dismiss, and then the government can reply to that. That's like another month. So it's not an ideal situation. Giamatti, what is the informal Facebook poll? Yes. We're in favor of a settlement too, Giamatti, but there has to be
two to tango.
There has to be two parties that have a settlement.
If we were offered a settlement,
then we could go to you.
Then we'd be cooking, but we have not had anything like that.
Yeah. Oh, Nebraska's now 44 months. That must have changed yesterday, because I actually looked yesterday and did not see that. Greg, I'm going to go to uscis.gov right now and see if Nebraska had popped up to that, because that again is a material fact for purposes of what we're talking about. Let's take a look at Nebraska. And Nebraska is in fact 44 months, Greg.
Wow.
Santa Chupa, holy son. So they're both 44 months now.
Yeah.
I think we'll have to include that in an update. We'll get it with our co-counsel. I'm back from vacation, so we'll move there. We are tired of waiting. Hayes, trust me, we are really tired of waiting. 41 months, thank you. So we are joining other cases. No, you are not joining. The judge has asked for the position. The other lawyers don't want to join.
Right.
Although their cases, if a class certification is granted, they would have no choice. They'd have to opt out of our case, right, which I'm sure the judge would not look on very kindly.
We don't have objections if people end up joining us, as long as it doesn't delay things.
Yeah, as long as
it doesn't have any impact on the timing, we don't care. To the extent that it slows our plaintiffs down, then we have a problem with that.
Yeah, if you guys, I think you should all be submitting expedite requests at this point, because they're coming back and saying, "Oh, nobody requested an expedite," or the people, let's say the ones that were approved quickly were expedites. All right, everybody submit expedites. Just go ahead and do it. Create the record, and let's see what happens. Tell your lawyers to submit expedites. What cases you'll be joining? Not the 601 has nothing to do with 601A.
Yeah.
What's going to the waiver case? We already talked about
they had different. I wish they had different form numbers.
Yeah. Waivers. I don't know what you're talking about, Daniel. You believe
they want to dismiss all 601A waivers, so no hope of them. Oh, I mean, I guess he's asking, are they like basically going to deny the cases just to get rid of them? And
no, they won't do that. No, that would, they've never done that ever. No. It's not an issue. They can't do that. Where with EB5? Yeah, I already talked about the Iyer case, my friend. Yeah, retrogression's a toast because they've already used all the EB5 numbers for this year. They've used them all. There are none for India. None. And they don't expect any flow down for India. So, yes, it's backlogged, which means they could adjudicate it, but, what happens to it then? Manny, even amendment and registry bill, I guess, then the registry is not ever going to be amended while the current GOP is in existence. Punto. Greg, do you disagree?
No, I don't. I mean, there's basically
there's
a trifecta that has to happen
in
order for immigration legislation to happen. One is you have to have a Democratic president. 2, you have to have a Democratic House. And 3, you have to have a Democratic Senate with at least 1 or 2 more seats. And then they will kill the filibuster. And then you can actually move legislation from the House to the Senate to the president, and that should get things flowing. Those 3 things have to happen. That's not that, hard to envision. We were only 4 seats away from a Democratic majority in the House this go around in an off-year election.
Well,
and you have I think the Democrats are the favorite to win the presidency next go around, especially if Trump's the nominee. And then in the Senate's the tough one. The Democrats have a lot of seats up this coming year, and they're going to have to win them all, and there are a couple pickup opportunities. It's going to have to be a great year.
We'll see.
So
Daniel, keep asking this. The government will file a motion to dismiss with the court. That's the case. It's saying the court has no legal authority,
right,
to force us to do our job. That's what the government. They're going to do that. They always do that.
Right.
But that is not us. They're not going to individually dismiss your pending waivers. No.
Let me say also in these cases, the motion to dismiss for a lot in these cases is really there's sort of 2 trials. There's the paper trial, and the motion to dismiss is essentially after all the back and forth. That's where they're asking the judge to rule in the government's favor. And then if we survive that, then later on, eventually, then we actually get to go in front of a judge and have the real trial later, assuming we don't settle it in between, which a lot of times happens. If you win the first go around, the government's a lot more inclined to settle before the second one.
So again, Shaylee, thank you for submitting expedites on the 601. 601A should be doing the same thing. Again, we've got the facts in our case. We've got strong facts. We'll go from there. All right, Greg, that's the end of today's questions. It's great to see you. Are you going to do men gray for men? Just kind of make it darker again?
I like gray. Speaking of, you've been gray for like as long as I've known you.
For about 40.
You're gray like in your 20s.
I was in 20s. I was gray. That's kind of I had a lot more gray hair back in the day. I just had a lot less.
Yeah. All right. No, I like it. I like having the mix, and I don't care if I go all gray. I'm not. I don't care about being bald. I don't care about being gray.
All right. All right. One last question. Congress hasn't responded to me for 4 months. You mean, I assume it's your senator or congressman that responded to you. All right, everybody. Great to see you. We'll be back next week at noon. I'll be live tomorrow at about 1:30, a little late tomorrow because I've got another event going on, and we'll go from there. Greg, we'll see you later, Barrett.
Take it easy.